today I'm going to give a brief overview of some of the key points. On any one topic that I bring up, I could probably talk for an hour. But I'm going to try to go through some of the big issues that we see so that you can identify an issue that may affect you or your loved ones. The first thing I'm going to talk about is guardianship avoidance. What is guardianship? Guardianship is when an individual petitions the court to say so-and-so is incapacitated. They could be asking to have the court determine that individual to be fully incapacitated, meaning unable to make any medical or health care decisions. The court may remove their right to vote, the right to marry, the right to do estate planning documents, the right to determine their residence, the right to determine health care. We don't like to have to do a guardianship, ever. We always look for the least restrictive alternative, always. And the way to have a lesser restrictive alternative when somebody loses capacity is to have appropriate documents in place that allow your loved ones to take over in making decisions and assuming responsibilities so that you do not have to go to guardianship court. If you do not have a power of attorney, a health care surrogate in place, there is a very high likelihood with a disease that might involve dementia, that if you get dementia, that you're going to end up in guardianship court, because that will be the only way your loved one will be able to step in and get a withdrawal from your IRA, or get access to individual assets that are not jointly held, or to make a decision about placement, particularly if placement involves placement in a secure facility with someone who has wandering tendencies due to dementia. So you really want to avoid a guardianship. The most uncontested guardianship is probably going to cost $6,000 to $8,000 in legal fees at a minimum. And if it's a contested guardianship, you can run into the tens of thousands of dollars. And I'll briefly talk about that. So what's the quick, simple fix for guardianship? That's to have a good power of attorney in effect. If you have a good power of attorney, that's a document that says, and I have one, I've had one for years. I recommend all my clients have it, whether they're 25 or really over 18, they should have it. A power of attorney says, in the event I'm unable to handle my finances, this is the individual that I name to take over all of my financial affairs, and if that individual cannot do it, here's the alternate person that I name. Those documents are effective immediately, but they're extremely important. What I'm looking for in a power of attorney, and you may have those documents in place, is special language that will allow me to do planning to get VA benefits or Medicaid benefits for any individual that doesn't have at least $500,000 plus set aside to be able to pay for their long-term care costs. And that's an arbitrary number that I pick, but in my opinion, anybody that doesn't have a pot of about $500,000, if you're facing a progressive illness like Alzheimer's or Parkinson's, that's how much you might spend. And that's just from experience. But if you don't have that amount, then you may need to access Medicaid, and I'm going to talk about that. And I want to have the appropriate language to be able to do the planning for Medicaid if we need it, or for VA benefits. An advanced healthcare directive is a document that says, anytime the medical provider sitting across from me thinks I'm unable to give informed medical consent, this is the person who can consent to medical care. It's extremely important. That's what Terry Schiavo did not have. She did not have that, and she did not have a living will. An advanced directive can be utilized on a very temporary basis. For example, You might have a drug interaction that makes you foggy or makes you not lucid for a very short period of time. And so your healthcare surrogate may take over under this document, make a decision. As soon as you recover capacity, then you are back in the driver's seat and you're able to make your medical decisions for yourself. Sometimes an advanced healthcare directive is not adequate, even if it's well drafted, and that is, and we do have to go the guardianship route. That only occurs when the individual has such severe and difficult dementia that they become non-compliant or compatible. And that does occasionally happen. It's rare, but it occasionally happens where the individual is running away, is paranoid, and is physically completely non-cooperative, refuses to go to the doctor, refuses to accept medication, will knock somebody's hand and won't accept the medication. In rare cases like that, even with the documents in place, sometimes we need a guardianship to have authority to impose medical care on a non-compliant individual. So that rarely happens, but it does happen. A living will, I incorporate them with my advanced directives, but that's the document, most of you probably have it, that says I'm exercising my constitutional right to refuse medical treatment. I'm putting in writing in advance, because if I'm end stage or in a coma and I'm terminal and there's no hope of recovery, I am asking for all medical treatment to be withheld except for palliative care, pain relief, so that I can die a natural death. Do not artificially keep me alive, even with artificial feeding, even with artificial hydration. It's a discussion every single person and all of your children should have once they're over 18. They should make a personal decision for themselves about whether they want a living will. What we do know, and this is extremely important, is that if you discuss your wishes, if you do decide to have a living will, which 99.5% of my clients do want, if you decide you want that, the best chance of easing the pain of your loved ones, if they have to enforce that, is for you to express this wish repetitively while you're healthy and in advance. So talk about it with your children, talk about it with your loved ones, let people know that these are your values, this is your decision, because what makes a family, I face families all the time that come to my office and say, and it's one of the things we talk about, is it time? You know, do I need to do a living will? You would think you would just have that discussion with your physician, but often I have that discussion with family members. And what eases their conscience and eases their pain is when I explain to them, this is not your decision. You promised as a healthcare surrogate that you would enforce this decision. This was your spouse's decision. That's what they wanted. You promised that you would honor that decision. So when you enforce a living will, you're not doing what you think is right. You're honoring the wishes of your loved one. And so that's a very powerful document, and I highly recommend everybody have it. I recommend all your children have it. In estate planning, obviously most of you probably have estate planning documents. What I tend to see when clients come to me and they're dealing with an early diagnosis of Alzheimer's or Parkinson's is that they've naturally named their spouse, who is now facing a progressive illness, as the healthcare surrogate, the power of attorney, the trustee, the personal representative under the will. Why? Because that's what we all do. Once you have this diagnosis, you need to revisit your current documents and say, whoops, I may have to change that. You know, now we know who's incapacitated, and that individual has to be removed from your documents. And that's important to do. It's a very easy thing to do, but it's one of the things that is commonly overlooked. Also, you probably left your estate outright to your spouse. Well, now your spouse is incapacitated. Do you really want to leave your estate outright to them? No, you want a trust. I mean, you want them to get the money, but you want a trust. And now you have the opportunity to plan for that. There is a planning tool that many estate planners are not familiar with that will allow a well spouse to leave 100% of their estate of any amount in a special needs trust for their disabled spouse. If that is a pure special needs trust, which is a very technical term, but it's a trust solely for the benefit of your disabled spouse, if that trust is under will and not in your revocable living trust, which confuses people, it is Medicaid exempt. So if the well spouse dies, unanticipated, and probably the minority of the cases we see that, but if the well spouse dies before the ill spouse, when I'm doing estate planning, I put the assets of the well spouse in a special needs trust under will for the disabled spouse. And that way the disabled spouse has 100% access to the money, but believe it or not, it's all Medicaid exempt. And if we need to apply for Medicaid, they potentially could have $1 million in trust. It's 100% legal. It's in the Florida statutes, and they can qualify as if they're a pauper under Medicaid. It's a very, very powerful planning tool. It is very underutilized. So that's the type of sophisticated estate planning that we do when we know what the fact pattern is that we're most likely to be dealing with. So I highly recommend some consideration be given to that. And there's some fun special rules. For example, if it's a blended family, the well spouse cannot name her children. Say the well spouse is a female. Her children cannot be the trustee for the disabled spouse. It has to be the disabled spouse's children or a neutral third party. So there's some built-in safeguards. And whatever's left in that trust that is not spent for the disabled spouse can pass on to the heirs, whoever you choose, free of a Medicaid lien. So it's an extremely valuable, important estate planning tool, and it's something to consider. I'd like to talk briefly about voluntary guardianship. I started out by saying guardianship is a legal process where the court declares an individual incapacitated and then names the guardian who has authority to make decisions. And it doesn't have to be a full guardianship. Sometimes we can leave the right to vote, the right to choose who you socialize with, the right to drive. We can sometimes retain certain powers. But there's another tool called a voluntary guardianship that, in my opinion, is very underutilized in the disabled community. I use it a lot for macular degeneration. A voluntary guardianship is a process where an individual who is not incapacitated applies to the court. So I could apply to the court. I could say, Your Honor, I have capacity, but I don't want to manage my finances any longer. And I don't really want to do a power of attorney because maybe the person I'm appointing, I'd like to have them supervised by the court. I'd like to have them bonded. I'd like to have them do annual accountings. I would like to have them be supervised by the court. Good reason is I have macular degeneration, or maybe I have very mild cognitive impairment, but I still have my wits about me. You can petition to the court and ask the court to appoint the person of your choice as your guardian of the property only. And then they're subject to court supervision. They have to post a bond. They're highly regulated in terms of what they can do and not do, and it's a and if at some later date you decide you don't want that person, you still have capacity, you can go to court and say, whoops, I want to switch to another person. It has no impact on what we call the guardian of the person. They can't make any social decisions for you, placement decisions, healthcare decisions. It's purely for finances. I use it a lot, as I said, for macular degeneration or some other impairments where the individual wants to, obviously has capacity, but they're just ready to let go of the control and they want the court supervision. It's a much less expensive type of guardianship to implement, and there is no finding that you are incapacitated. In fact, you must have a doctor's letter attached to the petition saying, I have capacity, I know I'm delegating the authority to manage my finances to another person, and I understand what I'm doing. So sometimes instead of going the guardianship route, we go that route. So there is this interesting process that you can utilize with court supervision. Everybody, in my opinion, should also have what we call a pre-need guardian designation. In Florida, if you know who you would want to be your legal guardian, you can fill out a form that says, if a guardianship is ever required from me, this is who I want to be my guardian. And that form can be filed today with the court or when a guardianship is filed. The individual named in that document is entitled to a presumption, but they should be appointed the guardian. And that presumption can only be overcome by clear and convincing evidence. Now, what are the types of cases where I see that's extremely important? In blended marriages. Very important. You've been married to one spouse for 50 years, you have children from the same marriage, everything's copacetic. It's very unlikely that there could be a contest over who would be the guardian. But what I see is many blended families, people that are in their second or their third marriages, and the children from the first marriage stand down, let mom or dad run the show until one of them is incapacitated. As soon as they sense that mom or dad, particularly when it's dad, who's always kind of been an authority figure, as soon as dad is, it can be mom, but it's more commonly dad, as soon as dad suddenly gets a little bit soft and a little bit forgetful, those kids rear up their head and try to move in, knock that second or third wife out, and they do it by filing a guardianship. And if you are in a blended marriage situation and there is any potential for incapacity, I strongly recommend you consult with an elder law attorney, that you have as many safeguards in place, and that we maybe discuss some advance warning to the children about what your wishes are and how you want things handled, because those are the nasty cases that can run into tens of thousands of dollars. And it is a form of allowing, I'm seeing this being utilized, unfortunately, in some cases, for the children from the first marriage to take over the finances. And they'll say, second wife, third wife, she's not taking good care of dad, I want to remove him from the home, I want to take him to Texas, I want to take over all the finances, I want to, now that person, that the other spouse is stuck with, well, what support am I going to get? When you're a caregiver, and you all know this, and I know it because I've been there personally, it takes everything out of you just to get through the day. It's your proudest accomplishment of your life to be a good caregiver. It's the most emotional, and sentimental and powerful thing that you can do. And if somebody comes in and attacks you when you're giving everything you have to caregiving, it is beyond devastating. You simply don't have the reserves to fight off an attack. And I don't really want to scare you. Many of you in this room do not have that situation, and it certainly doesn't happen in every blended family. But those of you that have difficult children, you feel it as I'm talking. You know that it's your fact pattern and that you should address it sooner rather than later. For those of you that have loving and intact families, and you know that your spouse who's a caregiver is going to be supported, and you've developed a family plan, you don't have to worry about this because you feel it. You feel it in your bones. And you know, people ask me all the time, what can I do? What's the best thing that I can do to plan for old age, even if, you know, if I'm not a millionaire? Or, I said, really doesn't matter if you're rich or poor. You will have the best aging experience if you have a loving and caring family that's copacetic. And I've seen these cases with multi-millionaires. It's not just dollars, and it's not just public benefits that makes this journey a successful journey. A lot of it has to deal with the family dynamics, and a good elder law attorney should address the best possible techniques for dealing with what your concerns are. I had one family that was a husband and wife. I love this story. They were husband and wife. They had no known disability. They were perfectly healthy. They had 7 children. 6 of them were in the medical field. Nurses, doctors, hospital administrators. The sweet, loving, kind, nurturing, caregiver kind. The other 6 were high-powered, this is how the parents described her, high-powered, in control, domineering personalities. And they wanted to name their sweet, loving school teacher daughter in their advanced healthcare directive. And they knew that the high-powered, domineering children were going to try to plow her over because they were all doctors and nurses and hospital administrators, and geez, they were much smarter than their loving and caring, sweet school teacher. And they literally hired me to videotape them and interview them when they signed their advanced healthcare directives, and to explain their wishes and their values. And it's still sitting in my vault, because they told me that under all circumstances that I was to defend the role of their choice for their healthcare surrogate when and if the day ever came. Now that's a very unusual case, but I thought it was pretty clever of them. Pretty clever. So we have this very fun, sophisticated video waiting for the shoe to drop if it does. Very unusual. All right, so when do you need to worry about governmental benefits? If there's, if you feel that you do not have adequate resources to cover your long-term care costs for yourself and your spouse, then you need to consider benefits. Do I have any vets in the room? Yep, I do. There's some excellent VA benefits called aid and attendance for non-service connected disability. I like all my vets to be in the healthcare system. The VA healthcare system is a healthcare system that is now expanding home care benefits for veterans. But in addition to that, if I have veterans that are under a $80,000 asset test, in need of assistance, medical assistance, and are spending virtually all of their income on care, for example, the assisted living cost exceeds their income, or their home care costs exceed their income, then they can qualify to marry vet for over $2,000 of health a month of benefits for a non-service connected disability. And if they pass away, their spouse, surviving spouse, is able to get about $1,100 a month of benefits should he or she become ill. Those are very, very powerful benefits for lots of my clients are just a couple of grand short to get into the assisted living from their income. And these can be very powerful benefits. The VA is overwhelmed with the number of veterans applying for these benefits. The average wait is about 150 days to get your application approved. For the vet, about 400 days for the surviving spouse to get the application approved, but the benefits are retroactive. If you want to see whether you're possibly eligible for these benefits, do not go to the VA and report your assets if you're over $80,000, excluding a house and a car. Go to an elder law attorney, plan with those assets before you report them to the VA. Right now, there is no look back like we have for Medicaid on transfers of assets before you go to apply for VA benefits, but they are now doing everything possible to impose a new look back at 36 months. And for the first time this month, when you go to apply, this is brand new, hot off the press, just made public 2 weeks ago. If you go to apply for VA benefits, before they approve your applications, they're checking your assets against your 2012 and 2011 tax returns to look for transfers, to look for other triggers. So applying for VA benefits just got a whole lot more complicated, and there's a lot of companies out there saying we're VA planners, we're Medicaid planners. I guarantee you they're not up to date for this. I just spent all day in West Palm Beach for a seminar that was not recorded. It was restricted to attorneys. Non-attorneys were not allowed to attend. And the director of the pension department for the VA flew down from Washington, D.C. and lectured to us on all the changes for over 90 minutes. It was really an amazing event. In addition to VA benefits, the most common benefits that people seek out are Medicaid. There have been massive changes undergoing in Medicaid in the state of Florida, and none of this is affiliated with Obamacare or the Affordable Care Act. Obamacare or the Affordable Care Act only impacts the under 65, for the most part. I mean, without getting too technical, the Medicaid reform is a Governor Scott program to move all individuals on Medicaid to a managed care model. And it took effect in Sarasota County on September 1st. It will take effect in Manatee County on February 1st, so it is not yet implemented in Manatee County. So why am I talking about Medicaid? I'm talking about Medicaid for long-term care. If you need assistance with some home care, assistance with assisted living costs, or assistance with skilled nursing care. There are limited Medicaid programs that will give you about 6 to 8 hours a week of free home care if you qualify. It will give you about $1,200, $1,100, $1,200 towards assisted living costs if you qualify. The Medicaid program for home care and for assisted living has a long wait list. It is not guaranteed to be funded, and most of my clients are on that wait list for over a year. So planning in advance is extremely important. But often, you know, that $1,200 is just enough that you need to, or the 8 hours of free home care is just what you need to be able to stay home. The only Medicaid program that does not have a wait list is the Medicaid that pays for skilled nursing care, which nobody wants. But it's there. If you qualify for that program, there is no wait list. Now the qualifications And this is for people who need long-term care. Your Medicare is your payer of choice for rehab after 3-night hospital stay and short-term rehab. But beyond that, Medicare does not cover, gives you very limited home care, but some important home care. But after a hospital stay, you might get 2 or 3 or 4 weeks of PT or OT, but then it drops off. Medicare is not designed to be a permanent program for these types of services. Medicaid is the only one, and it's designed for the poorest and the sickest in our country. To qualify for Medicaid as a single person, you're allowed to have a home, a car, a burial plan, under $2,500 of cash surrender value in a life insurance contract, and $2,000 in the bank. If you're a single person, married person, you have the same criteria, but the well spouse is allowed to have $115,000 of assets. Now, there are many planning tools that are 100% legal, approved by Congress, part of our laws, that will allow you to do planning if you're over those asset limits. And frankly, I'm not interested in planning for millionaires. This program is not designed for millionaires. Although there are cases where people have substantial assets over that asset limit. Maybe the well spouse is not so well. Maybe she's facing cancer. Or maybe he's facing, major heart disease. And so they may, the well spouse may have significant care concerns. So I look at every case on a case-by-case basis. What we do when we do planning is we go through what's allowable by law and what's not. And the client picks and chooses whether they want to do planning or not, and if the pain of planning is worth the reward. You don't do planning when your client's ready to go into hospice. You do planning when you think somebody's going to have a fairly long life expectancy and they're going to outlive their resources. So it's something that pretty much only an elder law attorney specializes in. And there are these Medicaid planning firms out there, Medicaid Done Right. There's just a bunch of them now. These are insurance people who have learned the Medicaid rules and pretty much sell annuities. I believe that many of them are doing an unlicensed practice of law. They'll typically charge about half of what an elder law attorney will charge, but they can't advise you on your Medicare rights. They can't advise you on what happens if there's an illegal discharge. They can't advise you on whether or not a living will makes sense or how you enforce that when you have a facility. They're not able to look at anything holistically that's going on with you. They're able to process some paperwork and sell an insurance product. So I have some real issues with how they're practicing. Many of them say, we have an attorney back in our office in St. Louis or Miami or Clearwater. Under the bar rules, if a lawyer's not meeting with you face to face, they are not representing you. That's considered inappropriate. And that's for any kind of company. So Medicaid planning is a very important tool. One of the things that I also try to do is make sure my clients maximize their Medicare benefits. Why? Because they're pretty much free. You have a Medigap policy. One of the little tips that I want to give you is that most of us wait for our physician to say to us, oh, you should get some Medicare at home, let me order that for you. And then you get a script from your doctor, or your doctor recommends that, you contact a home care company like that bills Medicare. Infinity happens to be in this building. I use them all the time. I think they're wonderful. There are many other great Medicare home care companies that just bill Medicare. What I find is the physician often is not thinking like a Medicare advocate. And there are many times when you may feel, I need more home care. What you can do, and what I recommend you do, is contact your home care company, if an Affinity or one like them. Ask them if they will come out and evaluate you. If they think that they could provide services for you and correctly bill them, honestly bill them to Medicare, they will say, you know what, I think you meet these Medicare criteria. We need to contact your doctor and ask your doctor if they'll order the home care. 99.9% of the time, the doctor's happy to order the home care, right? The doctor's just not thinking of it. They're busy. So if you have some short-term problems and you feel your loved one might benefit from PT or OT or some home care, call your doctor. You can call your doctor and ask your doctor if there's any chance they can order it, or you can contact any home care company of your choice that bills Medicare, ask them to evaluate you, and then they will, and then you and or them together can approach your doctor, and your doctor's gonna write the script, because the doctor wants you to get everything that Medicare can possibly provide. But what I find is that the doctors just fail to think about it enough. So if you have, your loved one has a flu, or they start falling a lot, or they seem to be reacting badly to medication, all of these things can be a trigger for additional Medicare home care benefits. So think about that and advocate for that for yourselves and for your loved one. Oops, we're already 45 minutes into this. If anybody has long-term care insurance, wonderful. Do not hesitate to utilize it. I do review those policies sometimes for clients, but be sure you know what you have. Contact your carrier. Sometimes there's ways to shorten up the elimination period. Almost every contract has a 90-day elimination period. Sometimes there's some tricks to shortening that. For example, instead of, some contracts will say you only have to pay 2 days in a week to qualify for 7 days towards the elimination period. So we like to get that going earlier rather than later, but those are really important. I'm going to quickly talk about this Medicaid changes that have gone on, and then I'm going to ask for questions. As of September 1st, anybody who's in any Medicaid program, whether it's for home care, assisted living, or skilled nursing care, is going to be asked to choose a provider, like an insurance company. In Sarasota County, there are now 3, United, American Elder Care, and Sunshine Tango. And this company will assign a case manager to you, and will have a contract with the individual facilities where you would either get the home care, where you're in assisted living, or where you're in a skilled nursing care. And the state has done this in order to hopefully provide better services to people, but also monitor care. And this is brand new in Sarasota County. It's caused a lot of confusion, but the enrollment is effective now, and it seems to be working pretty well. But there is now an entity, which is an insurance type of company, that is an HMO model monitoring the care that you're getting. And that creates a whole range of issues. But it's something that we've been studying and researching and monitoring. The Florida Bar Elder Law Section has formed a task force. We meet, it's only 15 lawyers from around the state. I am on that task force. We meet every week for an hour to discuss and monitor the implementation of this program. We're meeting with Herschel Mintz, who's Chief Legal Counsel for the Department of Children and Families, advising him of the problems that we're seeing in the implementation of the program, and trying to correct mistakes as they happen and to advocate for this population. It's a very exciting committee that the elder law section has put together. And we recently got tapped by the Kaiser Foundation. Have any of you heard of the Kaiser Foundation? They're a fabulous national not-for-profit that monitors all kinds of healthcare issues. KaiserFoundation.com is one of the best websites about healthcare in the country. And they're tapping into our committee to draft research opinions for the federal government. So that's pretty exciting. So those are some of the big political trends, some of the big reforms that are going on. I know I've droned on for about 50 minutes here now, so I'd like to open the floor to questions and any comments that you might want to make. Yes?
I'm afraid we showed up a little late, but did you, I noticed this special need trust for under will.
Yes.
Did you talk about that? And if you did, I'll ask you what you said privately.
I did talk about it briefly. I'll quickly summarize it and I'd be happy to speak to you privately. It's an estate planning tool where if you have an incapacitated spouse, an ill spouse, really just a disabled spouse, doesn't have to be incapacitated. The well spouse, so say you're the well spouse, your wife is the ill spouse, you would be allowed to set up a trust for your wife under your will, fully funded with all of your assets in unlimited amounts. That trust, if you died before your wife, would be Medicaid exempt. So your wife would have access to this trust to spend for their care, but she would appear to Medicaid. Medicaid would disregard that trust. And she would appear to Medicaid as if she were impoverished, or she would only have her assets, whatever assets were in her name. But typically when we do that, we would move the assets from the ill spouse to the well spouse so that and I've used it many times, like if the well spouse gets cancer, we know there's a chance they may predecease their ill spouse, move all the assets to the ill spouse, all the money when they pass away goes into a trust for the wife, and that is Medicaid exempt. The trust can be administered by the wife's children, and the wife can qualify for public benefits, minimizing the spending of the estate, and whatever's left over passes to your heirs, free of a Medicaid lien. It's a fabulous tool. If you do it, you cannot avoid probate. You have to do a probate, which is a small price for exempting all of those assets and being able to avail yourself of public benefits. It's authorized by Florida statute, and it works. It cannot be under trust. It has to be under will, and that's statutory. Yes.
On that same topic, I understood you to say that if something happens to the well spouse,
Right.
it's in the trust to pass on to another trustee, and they determine what happens with the money. Does the trust say that it should be spent on the ill survivor?
The trust says it may only be spent.
Only, good.
It must be for the soul. There are many characteristics of it. One characteristic of a special needs trust is it can only be for the ill spouse.
Okay.
So you don't have, let's say you feel that the funds in the trust are adequate to care for your wife, you could, or more than adequate, you could leave as little as 30% in that trust for your wife, and you could leave 70% outright to your other heirs. So say you want to leave a portion, or you could leave 50% in trust for your wife, and the other portion gift outright to your children. But you're allowed to choose the amount. Under Florida law, you are not supposed to disinherit your spouse. You must leave at least 30% of your estate for your spouse. Before, that's called the elective share. In the old days, some people would just say, oh, I'll leave all the money to my son, he'll take care of my wife, I trust him, and many times it worked. But by law, we've said, the Florida legislature said, you can't divorce your spouse and leave him nothing, so I'm not going to let you die and leave your spouse nothing. Question?
Yes, we have all of our legal documents and estate plan and so forth. We had it drawn up in Ohio. We're now permanent residents of Florida. Do we need to do anything
Okay, so the question was, we did all our documents in Ohio, we're now Florida residents. It's a great question. I should have addressed it. Technically, if your documents were correctly drafted in any other state, they are honored in Florida. That's the technical answer. In my opinion, it's better if you're a Florida resident to eventually do Florida documents. Why? Because other states use different terminology, and it confuses people. For example, a lot of states call power of attorney for health care. Well, we really don't talk about power of attorney for health care. When we talk about power of attorney, it's for finances. And the language from state to state vary. People in Florida are used to reading the Florida documents with the Florida terminology, and they're most comfortable with documents that conform to Florida statutes. But it's not absolutely required.
Okay, so in that instance, you're saying if it would be contested, or if it would, is any interpretation ambiguous?
If you have a trust and the trust says this must be interpreted according to the law of Illinois, it makes a much more complicated case. I really like, especially the power of attorney and the healthcare directive to be Florida documents at a minimum. I think that's extremely helpful. You don't, it's just easier for us to work with Florida documents. Sometimes people wait until they're ready to make a change. Like you might say, well, right now my spouse is okay as my power of attorney or agent, but maybe in a year or two they won't be. But if you've moved to Florida and you're a permanent resident, you want to make sure that it's clear that you're a Florida resident. Why? Because we have no income taxes here. So you want to register to vote. You want to get a Florida driver's license. You can even file a document that's called a Declaration of Domicile with the clerk's office. It says, I declare I'm a Florida resident. You want your primary banking to be moved to Florida. All of these are IRS and residency types of things. And usually you would eventually change your estate planning documents to Florida documents. Question?
Well, not really questions. I have a son that works for Kaiser Company, and he apparently is on this board because he's telling about it as a standby. Do they replace it? If they replace somebody for some reason or other, they'd have somebody take their place.
You have a son that's in the Kaiser Foundation, the not-for-profit organization that I was talking about?
Yeah, he's on that. He's a employee, I think,
right.
of the Kaiser Corporation,
right.
and is a standby for,
Is he named in your documents as an alternate in your documents? Is that what you're saying?
Not really, not yet.
No, not yet? Well, it sounds like you have a very successful son.
Well, he's working.
Congratulations. You know, when I started doing estate planning, I was shocked at how many families suffer with dysfunctional children. I would say in my practice that approximately 20% of the estate plans that I do involve excluding a child who is inappropriate. Inappropriate because of substance abuse, because of mental illness, criminal background, or just really difficult types of behaviors, or financially dependent. Another issue that I see with my clients is, and it needs to be discussed, are parents who have historically supported children, and now you're facing your own impairment, and you really can't afford to gift anymore, but you have a lifetime pattern of a dependent child. Something needs to be done. Discussions have to occur. Changes have to be made. The Department of Children and Families is very, very aggressive about seeking out elder exploitation of children who take from incapacitated parents. The state attorney's office, I met on Monday with the lead prosecutor for Sarasota and Manatee County. We took her to lunch, my partner and I, because we are seeing so many exploitation cases, and many of them are driven by family members. And one of the cases I have right now happens to be a Parkinson's case where, you know, a guy who's basically running a Ponzi scheme talked our client into giving a $140,000 loan, promissory note to basically a non-existent company. We are going to get the state's attorney's office to prosecute that case. Gifting is something that needs to be looked at very, very hard when you are facing your own issues. As we age, we naturally become more emotional, more sentimental, and more adverse to any kind of conflict. And because we become so averse to conflict, look, you're facing your own traumas. You know, life is hard. So when this kid calls you up, or when you get this pressure, you just go, whatever, I'll write the check. You know, I can't deal with it right now. I just need to get rid of this negativity in my life. And that's what I see happening. And many of my clients cannot afford to get Medicaid. If you're going to need Medicaid, and I think VA very soon takes the date you apply and it looks back 60 months, that's 5 years, to say, did you gift any money? And if you gifted over $7,600, you're ineligible for Medicaid. You know, penalties start to get imposed. So historic gifting patterns need to be looked at, and do not confuse this with the IRS gifting rules. And I'll quickly tell you this because everybody gets confused about this. I did when I first started practicing elder law. The IRS says you can gift, it used to be 10 years ago, for years, $10,000, now $14,000. You can give $14,000 to any individual or any number of individuals. You can give it to everyone in this room, up to $14,000 in any calendar year, and not have to report it to the IRS. That is a tax concept. It is not accepted by Medicaid, and it is not going to be accepted by the VA, both of which I believe will are going, well, Medicaid does now, VA will impose a penalty if you made that $14,000 gift. And the reason the IRS does this is because the IRS says there's a certain dollar amount that you are allowed to either gift or give away by inheritance during your lifetime. Right now, this year, that amount is $5,250,000.
That should work.
Okay? So any, per person, per couple, $10,500,000. So people that are over, if I had $6 million, it's a good idea to give away $14,000 every year to get it down, because everything over that threshold is taxed at about a 40% tax rate. So, but most of the people that I meet are going to be able to pass along their estates tax-free. And a lot of people have old documents that have these credit shelter trusts and these bypass trusts and these marital trusts. But now that their estates are $1 million or less, they don't need all of that. They can dramatically simplify their estate planning so that it's a readable, simple document. Why? Because unless you're over those dollar thresholds, you don't have to worry about that. But what the IRS says is, we don't want you giving away millions during your lifetime and then try to take the $5,250,000 when you die. So you must report a gift if it's more than $14,000 in any 1 year. That's just a simple form that you attach to your income tax return. And the taxes you owe on that gift are going to be zero. And that's subtracted off of what you give away when you die. So that's why there's a reporting requirement for gifting. And the reason the IRS lets you give away $14,000 a year is because it knows we all make gifts. And it had to come up with some dollar amount that just wasn't a pain to report. And so that's an arbitrary number because you give graduation gifts and wedding gifts and birthday gifts and Hanukkah gifts and Christmas gifts. And so $14,000 was just an arbitrary number of we don't care about it. And that's what that number means. But that number does not coincide with the Medicaid rules and the VA rules. And that is extremely confusing to everybody comes in and says, well, I just gave away what the IRS said I could give away. And one branch of the government does not coordinate with the other. And that's just the way it is, folks. And it's one of the most common problems. But once you face your retirement years and you know you're going to be facing increasing care costs, you should look very, very hard about supporting other members of your family and gifting. Question?
Quick one. About voluntary guardianship. Who do you typically select as a guardian? Is it an institution like a bank, or is it an attorney, or is it a friend?
Most banks will not do that, or financial advisors won't do that. You could hire a professional guardian if you did not have someone. I will represent guardians. I will advise them, but I do not act as a guardian.
Okay.
There are excellent professional guardians who know the rules, and you could hire. If you wanted to name a niece or a nephew or a good friend, or sometimes a CPA will do it for you. You can choose whoever you want. You're going to choose somebody you trust, or you're going to choose a professional guardian.
Okay.
They're pretty affordable, the professional guardians.
Okay.
Question?
Can you help me understand the difference between Advanced Healthcare Directive and the Living Will and DNR?
Yes, that's a great question. In Florida, it's very confusing. We have 3 different documents that affect healthcare decisions. I'm going to start with the DNR. The DNR is not a document a lawyer does. It stands for Do Not Resuscitate. It is a state form that is published by the state, and it must be signed by the individual and their doctor. The doctor has to co-sign the form. Or if the individual is too sick to sign it, their healthcare surrogate, who's the person named in the Advanced Healthcare Directive, can sign it. A DNR says, in the event that I go into cardiac arrest or respiratory arrest, do not resuscitate me. I don't recommend it for healthy individuals. I mean, if I had a little heart attack, I would want to be resuscitated. But many clients, when they're facing a chronic, progressive, long-term disease, say, if God sends me the quick exit through the heart attack or the respiratory collapse, I want that quick exit rather than the long, slow demise. And that's what you're opting for when you sit down in your doctor's office and discuss a DNR. Not done by the lawyer. The Advanced Healthcare Directive is a document it actually can be oral, but, well, a living one. Advanced Healthcare Directive is a written document that says, anytime the medical provider sitting across from me thinks I'm incapacitated, this is the person I designate to make my healthcare decisions for me. And very often when I have children, it's typically the spouse first, and then if I have good kids, if I have that dream family and 3 kids that all get along and they're all over the country, I'll name all 3 joint and several, meaning they can all do it together or they can all do it individually, which is very good for family members who are flying in and out to help take care of mom and dad. An individual name in an Advanced Healthcare Directive gives the facility or the treating provider a lot of comfort that they know who to deal with. Facilities really like to have that because it gives them clarity. If you're named as the healthcare surrogate under an advanced healthcare directive. You can consent to treatment. You can also withdraw treatment. If you do not name someone as your healthcare surrogate, by statute, there's an order, there's what we call a healthcare proxy. That's by statute. It says, if we don't have a written document, then we're going to presume spouse first, then adult children. Well, what if you don't, the children, you don't agree amongst the adult children? And it goes down a line of priority as to who can make healthcare decisions. A proxy cannot withdraw treatment, which is why I do not like people to rely on a proxy. The last in the line of the proxy is the social worker at the hospital. If you don't have anybody, say you're some homeless person off the street, they can't find the family, they don't have any connections, you know, the bottom of the barrel is the social worker at the hospital can make the decision as the proxy. A living will is, I incorporate a living will into my healthcare directive, but it can be a separate document. A living will, and the hospital will hand you a form for it every time you go in the hospital if you don't have one. A living will is a document that says, I have a constitutional right to say I do not want treatment. And I am putting down in writing a statement that says, if two doctors say that I'm terminally ill, in a permanent coma with no hope of recovery, or end stage, and basically the dying process has begun. Typically with a cancer patient, it's someone who stops swallowing. Do not artificially prolong my life by giving me artificial feeding tube, giving me hydration through an intravenous line, giving me continuous treatment. Allow me to die a natural death and give me all of the pain medication, all of the palliative care that I need. And that's basically to stop the prolongation of life. The medical providers really, really want that document. They feel most comfortable withdrawing treatment when the family's very clear, when the healthcare surrogate is named and they're very clear, these were the wishes and here's the documentation. Under those circumstances, you will have the most pleasant experience in a tough situation, whether it be in a nursing home or in a hospital or with hospice.
So a living will doesn't actually assign someone?
No, not typically. It can, but not always. It can be generic as well. That's why I personally like it just to be one document. The healthcare surrogate says this is who's going to make the decisions, and hey, and they're also going to enforce my living law. Because you want it to be one and the same. You don't want that to be different. So that's why I like to put them in the same document. Yes?
I'm wondering what of these documents you might carry around.
Well, you know, it really depends upon what your conditions are. Some people will keep a copy of the healthcare surrogate designation in their glove compartment of the car. Just because, you know, if you have an emergency and you're driving to the car, you have a car accident, it's there. Most people will give it to their primary care physician or to their family members because the family members are going to show up and know that they have it. And we scan all of our documents in, so we have an electronic copy. You know, the family will contact me and say, Babette, can you email it to the hospital? And now a lot of things are stored electronically. But, you know, typically a family member will give it to the named surrogate or whoever's going to be notified, and you can give it to your treating physician. Anytime you're going to go under anesthesia, you should bring a copy with you, because a lot of that's done in outpatient clinics now and not in the hospital, or if you're going to go in for a hospital admission, I bring it with you. The DNR is, you know, typically put on the fridge. That's where the emergency techs are trained to look for it. And in the facilities, they have them. You know, and your treating physician, again, would have that. It'd be part of the hospital record. Any other questions? I just want to thank you all for your attention. I could see that you really listened today. I want to wish you all the best with whatever you're dealing with. It can be one of the most loving and positive experiences of your life to have a successful caregiving experience. It gives me goosebumps when I think about what I went through. It's probably my proudest moment, and I hope you all had the same experience.